Okay, the chat is open. Welcome. This particular broadcast, we're going to be discussing 1099 original issue discount form. That is an IRS form, a pre-drafted form. Okay. As always mentioned when um, doing any type of explanation of forms, um, I want people to know and understand that the forms that are already created by an entity are copyright drafts of their proprietary documents at the IRS because they are a business. Um, the IRS has a right to create their own forms and documents. It's drafted according to the styles. Um, what do you call that? Perimeters, okay? And styles have to do with drafting instruments. And we're going to do some broadcasts about styles and learn um, a little bit about styles and forms and uh, what fields are in a document. But this particular broadcast is for people who are already a little bit informed about how to draft documents or wanting to learn more about using the forms that are available. Or perhaps they do not have knowledge of how to draft their own forms. And so, in that case, um, the use of the 1099 OiD is useful. And so, many times on the forms, the instructions, it'll tell you that you can submit your own documents, and so in that regard, you would just there are fields on there that has information that you're providing on your own custom documentation. You would just write in that section, see attachments. Okay, and so moving right along, we're going to get started. This demonstration or presentation is by Chris Hauser. He has a channel where he's um, sharing with the general public different how he has made use of these forms. And so we're just examining his use of the forms and what he's sharing with us his method and use of the forms. So let's get it. Welcome, welcome, welcome. Oh, before we get started, I would like to take a look at our subscribers. Hey, subscribers, we got 254 subscribers currently. Welcome, welcome, welcome. Okay. Now, when it comes down to these 1099 forms or any forms, what people consider it as the IRS tax documents, or this is not a tax document, even though it's issued by the Internal Revenue. All forms are not tax documents. Some forms are purposed for information to relay or communicate information. And so that's another thing that we need to have more broadcast on and uh, do a little in-depth explanation of what it means to communicate. Okay, we don't want no spammers. Okay, but the point is that the communication of a document is very essential to perfecting any type of contract or understanding. Okay, what I mean by perfecting and understanding, many of the people people that claim to be sovereign, okay, are processing documents without the understanding of what those documents are. And so, what happens essentially is that they tend to process the documents in a manner that is in not only ineffective but um, not having any understanding of written communication. They essentially wind up creating what's called fictitious instruments. Okay, and what I mean by fictitious instruments, and we'll look up the technical word, I mean, understanding the meaning and definition of that, is that they're creating things. Say, for example, um, they're using an information form incorrectly, okay? And they're filing documents and sending in tax forms and this and that, along with the information forms, not understanding what's going on. And so they'll get on the comment section and say, well, I sent in this and I sent in that. And they sent me back a letter and said this was a frivolous filing. Okay. And the reason that they're sending you a documentation saying that it's a frivolous filing is because perhaps you may have crossed the documents up. Perhaps they don't understand what your intentions are, what your intentions are for processing the documents that you have sent in. And so, in that regard, they could only summate that it's a fictitious instrument. Okay? And what I mean, summate, is every communication should have an end goal, okay, a protocol. What is your purpose for this communication? And so the rule of thumb in law is to give notice, okay? Tell people what you're doing or what you're attempting to do. And I would even suggest, instead of sending in a lot of different documents that you have been informed of online and word for word copying off of what someone else is doing with their documents, I would consider it as a wise choice to give the IRS a call and find out what their purpose and use for the forms is. They do provide instructions, but my suggestion is get it from the horse's mouth. All of the calls that are made to the IRS should be recorded. They should be. And so, in that regard, you will have evidence on file that even if you, say, for example, performed a presentment that appears to be fictitious. There, you can eliminate any conclusion that it was fictitious, intentionally fictitious or frivolous, okay, by that your actions are in fact in good faith, and it was your understanding when you sent in those documents that you should file these documents together, but you were unsure, and so you did file the documents, but you're asking them, you're not demanding for them to process the documents in whatever kind of way your favorite guru told you to. You're asking them, you're requesting that the documents be filed accordingly. Accordingly means however y'all file the documents, file them. Okay? And if the the method you're attempting to use is incorrect, inform you of that so that you can correct or amend the documents or digress. Say, oh, I'm sorry, I didn't know I couldn't send that. And it's okay to return the documents. I would make a statement that is, please return the documents dishonored. If there is a reason for the dishonor, please notify me of the reason. Don't just say it's frivolous. I have no way of knowing what you mean by frivolous. If I had a purpose and intent for sending these documents, what's frivolous about it? You know, it's not frivolous at all. I'm trying to take care of my financial affairs. So you wouldn't speak to them in that manner. But what I'm saying is that's the mental that goes along, mentally processing. Hey, I know that I submitted these documents in good faith. And so I wrote on the cover letter with the documents. I would definitely recommend that you send a cover letter or a preliminary letter. In other words, before you even send any documents, send a I'm gonna send I'm gonna send some documents letter. And I'm saying that, excuse me, in layman's terms of so down to earth, in that way, purposely not using any technical terms or anything like that so that you can understand. I despise when people claim to create some type of explanation of something, and all they do is just keep telling you the thing that you don't understand. Okay? And so I'm trying to give you clear and concise understanding with what I can relay, but to an extent, because this is an original issue, which means whatever you got going on, not only is it private and it's your personal business, but I would have no way of specifically instructing you unless you ask the question that is specific to your situation. Because everyone's situation is different, and the purpose and reason for processing documents is different. It will be difficult to make a blanket statement that you would use these forms for any one particular purpose, and this is how you fill it out, and this is what you do. For example, on a 1099A, no, everyone is not filing a 1099A for to process or report or document abandoned property. Okay, and the 1099A has the function of within the document to process information concerning acquisitions as well as abandoned property. And so, in that regard, I would definitely recommend that you read the instructions. Just read the instructions on the document. Sometimes people are telling you to fill out these documents and you can pay for something with the 1099 A. And although I want to be careful how I say that, although there is a process that's available to you to acquire things, viewing the 1099A as a catch all for whatever process you're trying to perfect. The 1099, none of these forms in and of itself create a binding financial instrument. You will need to send instructions as the bill of exchange informs you to do. The instructions is the tender. The instructions is the tender, not the form. The instructions is the tender, because if you're instructing to tender, then the instructions is the tender, okay? And so if you don't know any of that or understand what instructions I'm talking about, then it is my suggestion that you do not engage. Do not be filling out these forms and just sending them in. There is recourse. Speaking of recourse, people need to understand what recourse is. I mean, you can go to jail or you can be charged with some type of paper crime. So, since you do not want to be charged with any type of paper crime that you unintentionally engaged in, you want to send some type of informational document that is independent of any of these forms, informing them that of what your purpose is for presenting. That's why it's called a presentment. Any documents you're presenting for financial exchange. Okay. What I mean financial or monetary exchange, it's not that you can send a document in and get money. So whoever told you that and misinform you that you can get money with these documents, I would say carelessly disseminating information, and sometimes they'll purposely leave out the details because they want you to buy their class. Or and so if you should encounter any adverse action, they'll say to you, well, that happened to you because you should have took my class, where where you would have received the full process, the full uh, understanding that there needed to be some type of communication, letter of instructions that will remedy the lack of understanding of why you're submitting the documents, okay? And so, many times when people fill out their forms, they'll write on their documents without recourse. They'll endorse it without recourse. And so that one thing may make a difference on whether you will may be indicted for any type of paper crime or whatever like that. And also your explanation will assist in understanding that there was no ill will or fraudulent intent in processing these documents, okay? Now, just because you receive a letter back from somebody saying we don't accept this document, that may mean that they don't accept it in that form. You probably may have processed the documents in the wrong style. You may have, some people have on there, but they want to extract money from the trust and this and that, and not even understanding what trust it is that they're extracting from and what is the proper procedure to do that. And so they're attempting to do something that's not lawful. And so, in other words, if you have processed documentation that cannot be perfected, in other words, they're going to automatically be returned dishonored, then you need to find out what aspect of that presentment was considered dishonorable. If they say it's a fictitious instrument, then you may want to go back to the drawing board, period, as far as learning and understanding what is that document used for and how can it be used, what its purpose is. And as far as accessing trusts that are already set up and in systematically designed for that governmental entity to function, you have no clue how that entity operates. I would even go so far as to send a firewall request requesting information concerning that entity. I've seen a lot of people say, yeah, and they got this, and you're like, who is they? Who in the fuck is they? All right? Who is they? They could be anybody. You can't go in the court talking about they. Who is they? We need to identify who the hell is they. All right? And so sending a firewall request to get a full understanding of who they is would be helpful to you so that you do not send these accusatory letters. It's fraud being performed on my account and this and that. And, they're making money off of me. They have my name on the stock market and all of those myths that go along with the sovereign community input. You have, thank you, we just got another subscriber. Welcome. You will be sure. You want to be sure. This is why I say don't guess. Know the facts. Know the facts. Okay? Know your shit, you know. That way you can easily defend yourself against any attack or adverse action because you can clearly identify the good faith effort that you've put into researching and trying to understand these instruments and how they're used and what is set up and what is provided for you as a benefit, okay? Because what people don't understand about the Social Security Administration, the Bureau of Vital Statistics, and all of these companies, they understand that they are companies, all right, whether they have .gov on the end or not. They are corporate entities. They're in business to make money. They're not in business to make you money. Okay? Let's be clear. Now, whether or not you are entitled to interest secured by them is not a factor that I'm discussing. Okay? That's not what I'm discussing. Whether or not you're entitled to anything. That is the reason you need to send a follow request. Ask. Ask questions. I've gone to Google to ask questions, and Google has gotten very untrustworthy as far as any information you could get from the search engines. AI has taken over. It is a terrible innovation in regards that is useless, utterly useless in extracting information that can be verified. Even on the opposite of trying to verify something. Say, for example, you just want to learn, okay? Let's do this. I'm going to go to my own personal search that I did. And this is what I wrote. Do banks draw from the Federal Reserve? And so, no, this, don't pay attention to this. I put, do banks, hold on. Because that's how normally people would ask the question. So this is what we're going to do. I'm going to show you what I'm saying about the information is just totally and completely unreliable. And all their AI does is try to scare the crap out of people. This is why Yusuf is so adamant about all you have to do is go to ChatGPT and ChatGPT gonna tell you it's illegal. You're gonna go to jail because that's what it's trained to do. Watch this. Do banks Draw presentment via the Federal Reserve and final settlement in debt. Okay, this is one of the questions that I asked. Oh, now it's saying yes. Oh, wow. Okay, it must know that it's on display. Hold on. Let me see if I can reword it like I originally said it. They said no yesterday. Oh, I'm telling you, unreliable. So unreliable. Do banks draw on behalf of account holders? Okay, that was my original question. Do banks draw on behalf of account holders? Draw, I said, do they draw from the Federal Reserve and the AI claim no, they draw from their own accounts. What accounts they got? Hold on. We go, I'm moving cart before the horse. Okay. Do banks draw from the Federal Reserve on behalf of account holders? This is what I searched before, okay? Let's do it now. No. You see what answers you get? No. Okay? And so Yusuf is so trusting in the AI, he'll take that for an end all answer. And the AI is stupid. It said, no, banks do not draw funds or borrow from the Federal Reserve on behalf of individual account holders. That wasn't my question anyway. So the answer probably is no to that, but because that was not my question. If you change the the question asked, of course the answer is going may be different. Okay, and so if we worded it and said no, banks funds or borrow from the Federal Reserve on behalf of individual account holders. No, they ain't drawing on your behalf uh, from the Federal Reserve. They're drawing on their own behalf. I well know that. But what I am saying is, it is, do they draw from the Federal Reserve on our behalf? They borrow from the Federal Reserve on behalf of themselves. They're drawing funds on behalf of the individual account holders, okay? And so those are two separate things, drawing and borrowing, okay? But they put them together to confuse you and said the answer was no. The Federal Reserve System operates strictly as a banker's bank. Now, what does that mean? A banker's bank. That means they have exclusive access to the systems, okay? With their credentials and so forth. All right. And does not maintain retail accounts. Now, I ask anything about a retail account? I didn't ask anything about a retail at all. I did not ask anything about a retail. All right. And it issues personal loans. So it says the Federal Reserve system operates strictly as a banker's bank and does not maintain and does not issue personal loans. Now, did I ask, did the Federal Reserve issue personal loans? Did I ask, do they process transactions for individual members of the public? No, I did not. It's not my question. You see, it says institutional only. The Federal Reserve only extends credit and maintains reserve accounts for eligible depository institutions. Well, for one thing, and it speaks about the discount window when banks borrow from the feds through facilities like the discount window. They do so strictly on their own balance sheets to manage internal liquidity and meet system-wide reserve requirements or cover short-term cash deficits. Okay, so that are already understood. So what I did was I reworded the question for the dumbass. Uh, and I said, well, do the banks, let's do it again. Do the banks draw from, uh, what was my question? Hold on, y'all. I said, can banks deny granting a credit line? Okay. And it said, yes, they can deny you. All right. Which I knew that was incorrect. But see, if you don't know that it's not correct, then you would just accept whatever the AI say. Your rights after denial. Boom. Okay. Why would you have rights after denial if they have a right to deny you? That makes no sense. Adverse action notice. The bank must send a written notice explaining the exact reason for the rejection. And it right here in the smallest area that they could provide for you, this says free credit report. You have to get a free credit report, and Consumer Financial Protection Bureau has some allowances. And now the AI is asking, did the bank provide a specific reason or adverse action notice? Because the answer is no. The answer is no. Okay. Now, so you don't, if you reword it and say, can they discriminate? Instead of deny? Because that's what it is. Let's see what the answer is no. You see that? And it's completely illegal for any lender to reject an application. You see that? So I did all of that demonstration to demonstrate that you cannot trust AI for an answer just based on your question. Your question has to be styled in a manner that you can get the correct answer. That's my point right there. Okay. Now, it said that the banks do not draw on your account, okay? I asked, do banks draw from U.S. Treasury on behalf of the account holders? It said no. These are not none of my questions, just some crap they suggesting at that bottom. I asked, do the banks draw from the U.S. Treasury? I asked, did they draw from the Federal Reserve? And they said, no, 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 no. Okay. And that's mainly because of how I was posing the question. Do banks draw from the Federal Reserve on behalf of the account holders? No. Okay. So if you're being taught that the banks draw on behalf of the account holders, um, when you put your deposits inside of their banks, that is totally different than applying for credit. Okay, so we don't want to even ask that question. The question that I had to ask in order to get the correct answer or to validate was not how can I check my Federal Reserve account. I didn't put that on there. That's something they're suggesting that I ask. Or perhaps it's a question that's been commonly asked. And that goes to my point. How you ask the question matters. How to check my Federal Reserve account. Now, why would you think you have a Federal Reserve account if you didn't set up one? Hold on, where did that come from? To check a Federal Reserve master account. You didn't ask about a master account, but it's suggesting that you some it's giving the explanation of how to check a Federal Reserve master account or institutional financial services balance. Log into the official FedLine web portal using your secure credentials and token. Then open the account management information application to view real-time balances, daily statements, and transaction reports. Okay? Now, if you don't have that, how would you have a Federal Reserve account? It's talking about master accounts. Access requirements. Authorized access. You must be an authorized user or end user authorization contact registered through your financial institution. Okay? So there's two different type of uh, uh, authorized user. And you will be considered as an end user. Okay? And so, would you know that? To put that in the question specifically and say, not you, instead of saying my Federal Reserve account, and you would put the end user account, or you would question it specifically about end user access, end user authorization contact, and they registered you through your financial institution. Okay, so when you shorten the question too much, that's when it gives you any kind of stupid answer, which essentially is all the same, but if it's not worded properly, you will not get the proper answer. Okay, I would say a more valid answer. Okay, it says for technical help, call the Federal Reserve Customer Contact Center at 888-333-710. Okay. Account setup. Visit Federal Reserve Financial Services for enrollment details. Note, if you are an individual looking for personal banking, Treasury Direct, the Federal Reserve does not hold consumer accounts. You should instead check your commercial bank, credit union, or the official Treasury Direct website. Okay? So people need to understand that in getting information, even on the gurus, they're giving you incorrect information similar to the AI, to the best of their knowledge. Okay, to the best of their knowledge. And the banks cannot determine you are a financial risk. Okay? They're not allowed to do that. By what determination would they by what evidence would they determine you are a financial risk? Because of a low credit score, recent late payments. Okay? So basically, if they see you don't know how to provide a proper presentment, then they can determine that you are a minor and you don't know how to process financial instruments, and they can't do business with you. Okay? And so how the AI is wording it was how they would relay that information to you is different from how you would ask the question. Okay? So AI is extremely unreliable when you're wanting to verify anything. I just showed you proof of that. Because in the end, hold on, let's go back to it. In the end, I finally asked the question correctly to get the answer that I needed. And I worded it in this manner. I used a portion of how the AI worded it and said that banks go through the clearing agency and so forth. So I already was aware of the clearing agency. I knew to ask the question in that way. You wouldn't know that. You don't know nothing. If you don't know nothing about a clearing agency, you do not know nothing about that to ask that question properly. That's why you don't got no business processing these type of documents. All right. So anyway, I'll show you what answer I got once I worded it properly. Do the banks, okay? Let's go back. Do banks draw from the Federal Reserve on behalf of an account? The answer is no to that, because of how I worded it. Do banks draw from clearing agencies processed and routed through Federal Reserve banks on behalf of account holders? And it said yes, but now it doesn't want to answer the question. Do they or don't they? Hold on. Do banks draw presentment via the Federal Reserve and final settlement in debit? Yes. Okay. Under Regulation J, the Federal Reserve banks present items to paying banks. Who is the paying bank? You. The bills of exchange say that you is the banker. You is the banker. This is why it's a catch-22 question. Banks are only allowed to borrow, and you make them the drawer. Okay? When you request credit, lines of credit or loans, stuff like, you make them the drawer. Then they have what was called an event. When you apply, let's see. What is a financial event? See, and you would have to know all of that, okay, about the understanding of what an event is. Some people trying to file 1099-A documents don't even know what an event is. Okay? Just out of the blue because their guru told them they can file this. That's the event. My guru told me I can file this and extract all my money out my certificate trust and all that shit. And you cannot take nothing from the trust. You utilize the benefit, the beneficiary interest, okay? And since you don't know that, you don't need to be filling out none of these documents. A financial event is any occurrence, transaction, or happening that changes the financial position, okay? When people are trying to establish their own trust, that is an event. But you need to give notice of the event, okay? There's something that's changed. I've set up a estate, and I have a trustee, and my trustee is wanting to access and itemize all of my assets, and I would like to transfer. You want to transfer some stuff. Transfer rights and entitlement or whatever of entitlement. Okay? It says it's a transaction or happening that changes the financial position or monetary value of an individual, business, or entity. It includes everyday business transactions, major economic shifts, or accounting milestones. Okay? Accounting events, direct business transactions like sales. Okay, you sold your house or you sold your vehicle. Okay, that's an event. You purchased something. You purchased a home, or you purchased some real property, or you purchased an asset. Okay, asset depreciation. Perhaps the value of your asset went down. Your house caught on fire. All right, that is an event. Or paying wages that alter financial statements. Okay? Perhaps you had to pay a lawyer, all right? And you wanted to use a 1099 to document that. It's documenting it, all right? However, whatever the event was, you got to understand that these documents are processed based on some type of financial event. All right, some type of something. What do you want to say? Took a different course. All right. If you were dormant and you decided you wanted to make a purchase, now you are active in commerce because you are making a purchase. All right. Say you just sitting on your money. You ain't trying to buy nothing. All right. You just sitting on your assets. You ain't monetary assets. You ain't trying to buy nothing. All right. Your previous state was dormant. And so you in any transaction, um, in any type of situation where you are doing something different, okay? Here, you see right here, it says the Fed explain payment system, okay? I don't want to get into that because people who are wanting to do stuff like that, they have a lack of understanding that you need to have credentials to do that. All right, you need credentials, you need documentation that you uh, have some type of financial uh, institution in place, and they need to have a record of that you're allowed to do that. And they will also help you and um, uh, give you information directly through those entities if you have a legal right to access those type of processes. Okay, but there is a lot of liabilities attached. This is the reason why they require for you to have insurance. Okay, because when you go to dabbling into secure instruments and dealing with those type of instruments, you need to be aware of the implications of liability that is attached um, to what you're doing. And if you have no liability, say for example that you are exempt from liability, then you need to verbalize that off the rip. Okay? This is the reason why um, I do not recommend that anyone be filling out these documents that do not know anything about liability and exemptions from liability. Who's exempt? You are. But do you know how or why you're exempt? Because you're a beneficiary. Okay? Beneficiaries don't assume any liabilities, and somebody else gave you some money and now you responsible for that. You didn't have nothing to do with that. They just decided they want, and you have not even received any benefit from them setting up these trusts, uh, to your knowledge. All right. When people access welfare or Social Security or any public housing assistance, first home buyers grants, and so forth, they know how to properly access. They're set up to access these accounts, and they do so with papers. There's no money involved. There's no actual Federal Reserves involved, just paperwork that they're shuffling around, and it explains what's going on. It explains the event. This is why when you fill out an application, it asks you all of these questions. Okay? Questions to identify you, questions about who is who in the household, okay? Because they're processing presentments that, along with your application, um, that outline what is going on in the probate of your estate, okay? Um, I won't say the probate of your estate. In that manner, I would prefer to word that in a way where you can understand that everyone is assumed to have an estate, okay? A contract, uh, not a contract. Yes, an implied contract with the government, that the government will help you and protect you and provide for you in different ways. And that will add to your quality of life. Okay? And when they do um, provide you any assistance, say, for example, they said, we're going to assign you a public assistant, they process that through the probate court systems. And a lot of people are not even understanding that, and they're sending stuff to the IRS and thinking that the IRS has something to do with it. They're sending it here and sending it there, and they're sending it to the wrong entities, documents to wrong entities to begin with, that have do not have a right to access certain funds. And so, if you're trying to get funds from them and they don't even have the right to access, in other words, you're requesting them to access funds that they don't lawfully have a right to access, that's definitely a frivolous filing. Okay? So, we want to be understood who can do what before you start doing stuff. All right? Here on this video that we're gonna display in just a second, um, the content creator Chris Hauser, he said, I'll play this for you.
Google, hey Googles, what is a temple of justice? Google that. What's a temple of justice? Hey Googles, what's a temple of justice? They're going to tell you. Oh, well, it's a courthouse. That's like someone dragging you into a satanic. Here you are, a Christian believer.
Now, how did he?
Okay.
This is what I'm saying. First of all, Google gives wrong answers. So to just go off on a tangent, okay, based on a wrong answer to begin with, is not a competent way to go about your affairs, okay? Secondly, he said it's a courthouse. Well, how did he deduce from it's a courthouse to a satanic worship? I didn't see how that got to that. All right. And so we need to be careful of how other people are interpreting things. What is it that he's interpreting? It may sound intelligent, but to you it may, but it didn't to me. It sounded unintelligent.
So I went home and I did the research, and when I looked up justice in the dictionary, it basically said what I told him. I said, but he's telling me it's not. It's got to be something more than that. The one thing that I wanted to add that I didn't in the thing, in the last video, was thinking about the definition of registration. What is it you...
No. Don't be
Good
thinking.
evening, friends. Before I get started, I'd like to say a little bit about the language.
Hold on. Don't be just thinking you right about stuff. That's my whole point I'm trying to get to. You can't be just thinking that you right.
Good evening, friends. Here's a video I was talking about a couple days ago about getting out. This one here, I'm going to explain how to fill out the 1099 OID.
Hold on. Now, the only issues I take with that, as I stated prior to the demonstration or presentation, however you want to call it, is that the OID is a form, and he is making sort of a blanket statement that he's going to show you and present how to fill out the 1099 OID. And we'll see if he gives any instructions for you to send a letter of instructions or whatever. Let's see.
The 1096 and the 1040V. I've got some mock-ups here to break this down and explain them to you. But look, when you order these forms, they're going to come with, if you order OIDs, they're going to send you instructions, okay? It would behoove you to read these. There's very few instructions, and it tells you who's supposed to do it and who's not. This one, for instance, is super
So what
thin,
do it say?
and it's two of them. It's the 1099, the INT, and the OID. And so you're only going to read about half of this. And then, like when you get the 1096, it's a little bit thicker of a book. It's a little bit thicker, but it's got a bunch of them. Right, so all you're going to really be looking at is your 1096. Okay, so take the time to read these, folks. You're going to glean stuff out of them that's going to be beneficial when you go to write these, when you go to fill them out. The 1099 OID looks like this. It looks a lot like the 1099A. Okay, this is a scannable document. You have to order these and fill these out. You don't have to sign. You don't have to sign the back of the red one. That's all. This is all going to happen. The A's already assigned. That's acting like a check. So that's what that one looks like. And this one here is, a lot of you already got these, the 1096. Okay, the reason you're going to do these is this is how it works to get the money from the Treasury. The 1099A, I know a lot of people say, well, why would you use acquisition and abandonment as secured property? Because it really says
Well, hold on.
acquisition or abandonment as secured property. That means it's used for both of those types of things. And what you're doing is you're acquiring property or security from your trust. It's the acquisition part of the 1099A that you're using. And then these all fall together. You're going to use the 1099A. You're going to take that from if you're the dealer, you're going to get the 1099A from the beneficiary. You're also going to fill out these other forms, and I'm going to explain these to you right now. When you're filling out the 1099 OiD, it's going to have some fields in it to fill out. See, I got this one filled out, and you can screenshot it or whatever. But up in the top, up here in the top, left-hand corner, is the Treasury. See, it's the United States Treasury, 1111, okay? And then right down below that, you're going to have the Treasury's FIN number, the Federal Identification Number. And then right next to that, it's going to be the dealer's EIN number, okay? And then you're going to have the dealer's name, the dealer's address. This one here I've written out if you want to explain this to a dealer. But just substitute yourself if you're going to use this, say as the trustee. Someone else is a beneficiary and they hand you a 1099A. You're going to substitute yourself in place of the dealer, okay? I just put dealer in there because everybody seems like they want to try and get cars with the 1099A. This is how you're going to explain this to the dealers, okay? They'll fill out this. They'll put in all this information, right? And then you're going to get down here all the way at the bottom. That's the purchase order, okay? That's going to be the purchase order where it says account number. Purchase order or account number. With a dealership, it's going to be a car. The purchase order for a car. The account number is going to be, if you're acting as a trustee and you have, like, say, a company, and you want to, you're doing some work for the beneficiary. The beneficiary wants to pay you in a 1099A. Well, you're going to give him you're going to create an account number for that customer or that beneficiary. You'd put that account number in down there. Okay. Now up here at the top, you got purchase order. Okay. That's the purchase order again. And it's the amount. What is the amount on the purchase order? Okay. Now we're going to go over the numbers that say the dealer is going to do. Or if you're going to charge somebody to build them a porch on their house, a deck on their house, the purchase order is going to be that. That's how much you're charging the customer. And then you're going to have all these other blocks. Well, there's the calendar year, 22. Then you're going to have all these other blocks or boxes. You're going to put zero in there. $0.00. And I'm gonna explain that, right? It says federal income taxes withheld in box 4, for instance. Okay? You don't pay taxes, remember? The trust is responsible for the taxes. So you're not paying any taxes. There's nothing to withhold. There's also acquisition, early withdrawal penalties, market discount, and acquisition premiums. Those will all be zero. Okay. And then you get down here in the box, it says original issue discount, United States Treasury obligation. Oh, I kind of messed that one up. That's going to be the price of whatever. I put $0.00. That's going to be the price whatever the car is, or it's the obligation that the original discount.
All right, now we resume the broadcast. But before I resume the broadcast, I want to discuss and clarify um, why it is important to learn things for yourself instead of having someone else uh, just tell you what goes in each box. Because as he's even demonstrating what he would suggest that, when what uses the forms are could be used for. um Still, in all, people are not even really understanding, why do you do this? Why? What's the answer to the why would you do this? All right. People need to know the whys. Here you have a commenter stating, I must be dumber than a box of rocks. I've been following this subject for 20 years and still don't understand this. Well, I won't debate that, since that's your understanding of yourself, opinion you have of
The
yourself.
OID is going to be talking about. Okay, and then there's bond premium, tax exempt OID. See there, $0.00. State tax withheld, $0.00, because you're not a taxpayer. Remember that. You're the beneficiary. You're not responsible for the taxes. The trust is. Now, if they want to charge taxes to the trust, go ahead. Who cares? Take the money from the tax money from the trust if you need it. But you are not a taxpayer. That's the OID, folks, and it's pretty simple. Pretty simple to fill out, just like the A is. And I'm hoping that through all this, you'll get a firm grasp of what it is when you go to explain this to these dealers.
Well, how would you explain that when he's not even giving you any information to be able to uh, articulate that in any understanding from what he said? So, let's go in. Let's do a little comment mining.
This is how you're going to fill out the OID, and this is how you.
And also, everybody's not professing to not be a taxpayer, and so would you understand what he mean by you don't need to fill that section out because you're not a taxpayer? Well, you're not a taxpayer because you don't got no money to even be required to pay taxes. All right. um anytime you make a purchase, there are taxes assessed to that purchase. Okay. And so, why wouldn't you document in that section what portions of of the of the whole amount uh, includes the taxes? See, so his understanding of that document and what should be placed in each, the information that should be placed in each field is somewhat unreliable because he's not explaining that part. Whatever understanding he has, that's the understanding he has, but he's not doing a very good job of explaining his understanding of it. Okay? Let's go on to the next commenter. I've gone to two dealerships and they said no. But I asked them if they would hold the vehicle for 45 days until I receive the check, and I will add $5,000 to the price for holding. And they agreed. Okay, a holding is too. They may have even told you, yeah, man, we gonna hold we gonna hold the car for you, because they know you was stupid enough to believe that they was gonna hold it for you. If somebody else come in there and got the money to buy that vehicle, do you sincerely believe that these people who are required to pay taxes on these vehicles, they can defer the taxes but so long? And so people who are required to pay taxes on their assets, you think they finna hold that in hopes that you will pay? No, sir. In waiting for you to process a presentment? I don't think so. And so this commenter has commented, but you will see if you go to the video that several questions was asked of him or her, and they never answered the question whether they, whatever they was processing and asking to be done, did they complete that process? Acting like they just know what's going on and pretending like they done already processed these documents and all is well. Now, I will say this: people do trust Chris, the presenter, to give them information as far as processing documents based on the fact that he is a doer. He's gonna go to these agencies directly, talk to the people, ask questions. He doing the groundwork. Find out, can I do this? Can I do? And he testing the waters. He's sending off documents. He gonna send this and send that. He gonna send off some documents. All right. But that's also what kind of got him in trouble, because he too quick to just do, and even when he didn't understand that filing the UCC was a lien, that from my understanding of the lien process, um, you need to have a certificate of indebtedness, okay, which he did not have, and he could have obtained with his documentation that he had already certified letters and whatever documents that he sent. He sent it certified. He had a contract number. He could have easily gone to the courthouse and submitted those documentation to have a judge rule that he had a judgment on the obligation. And so once you have a judgment on the obligation, then you can proceed to lean on that ass, okay? Because the judge said that they owe you, and so that's considered a legitimate obligation, okay? It's been verified, it's been perfected, and that's how you completely perfect the debt instrument. It's a debt instrument saying you owe me, pay up. Okay, I got a judgment saying that you owe me, and use that um, judgment on summary judgment. Now, I don't want to give you incorrect information because it may be different in different states, but from what I have gathered and can share or will share with you is that when you do process those type of documents, that there is a procedure that you can somewhat streamline the process and go straight. It's not something you have to wait a long time to receive a default judgment. When they do not uh, respond, then and you assume, make the assumption that they acquiesce to the obligation, you may then take it to the court and receive a judgment. And so you will file for summary judgment, um, or file for a review of the contract and breach thereof. You need to claim that there was a breach. The person, not only was it a breach, but what is it called? A default. There was a default in the payment. Okay, and so um, meaning whenever they were supposed to process the payment back to you, they did not. And so in that regard, uh, you may receive, I said may, because I can't tell you how your court case is going to turn out. Depending on how you draft it, it may get dismissed. But when you have evidence of the obligation, it should not be dismissed. It should be considered valid at that point because he had all the ducks in a row. If he had all his ducks in a row, his next step would have been to seek for a judgment against the person or a judgment against the entity, um, or I would say individual, uh, that is obligated to uh, make the payment, all right, or process payment. And so, in that regard, once you receive a judgment, you don't have to sit up and wait on someone to pay on that judgment. You can then lien place an asset lien, okay, that this debt or obligation exists, and the person is responsible to remedy that obligation. And so that's what he did, but he did that in an incorrect manner, and it landed him in federal prison or in prison, whatever kind of prison he was in. He does testify that he went to prison for um, presenting his documents, but it wasn't for the documents that he presented. It was the way in which he went about placing the links without proper process, and he's just not understanding that at all. He's saying the the IRS agrees with me, and the Federal Reserve agrees with me, and they agree that the obligation was you submitted a proper presentment to uh, establish an obligation, but you did not do the proper process with which you can then take action and enforcement of that contract. So that's what we're trying to learn, understanding the enforcement phase of presenting the documents. What can you do if your documents are not received by an entity? And so I'm not gonna even continue with this presentation of this particular video based on that fact that I do know that he's not fully understanding the processes with which he can have the intellectual competence that you can rely upon in following his instructions. Okay? So, you all stay tuned to this channel, because whatever questions you have concerning documents, you can ask questions on this channel in the comments section. You can ask questions during the broadcast in the chat. You're welcome to ask questions, and we will answer the
And this is how
questions.
you, because they're going to say, how you get the money? Well, this is how. You're going to fill out the OID. Here it is. This is what it looks like. You can even take an example, fill one out, photocopy it, your OID that you have, and your 96, and fill it in for them, just as an example. Say, look, this is how you can do it. Do it like this, and explain it to them. And then you're going to have the...
Now, he's not understanding how you make yourself reliable for instructing someone else on how to fill the forms. I wouldn't suggest that either. If you're presenting these documents to somebody who don't know how to process them, then to me that's an indicator. Do not proceed any further with even requesting them to fill out any documents. I would not proceed any further without asking questions, not instructing anybody to fill out any forms that they're not even knowledgeable of how they work and what they're used for. Um, that places too much liability on you, um, as far as they can come back to you and say, you're the one that sent us instructions and told us to do this and do that, if they experience recourse because of it. Okay, recourse means an adverse action problem. All right. Nobody is allowed to send a bill and charge you. Every remedy for a bill is in the terms and agreement. Okay. Um, Understanding what they mean by that, that's up. I mean, I couldn't um, explain that for them what they meant by that, but I'll relate to you what my understanding of this comment is. Is he saying that the answer to the bill is on the bill? You don't need to send any additional documentations with it, 1099A, this and that, and this and that, and this and that. You may follow up with documenting the transaction, the event, with a 1099A or 1099 OID or 1099C or any other 1099S, that's for stocks. If you understand that you're a shareholder in that uh, corporation as an account holder, you are also equivalent to a shareholder if it is a secured credit transaction, which most bills are drafted from a secured exchange. All right. Um, this commenter is thanking him for his response to his question. Okay. And so he's understanding, he's relaying that he's getting a better understanding of the documents and how to proceed. Okay. And acquire remedy. All right, but he's not reporting that he got remedy. He's just saying that he think this is what's gonna be the the magic wand, and that's very unrealistic as well. I've gone to two dealerships. We went over that. They didn't respond and say that they completed the process and had any positive results. Okay, seriously, so appreciate you for this video. It's all the little details no one tells you on how to complete the process. Awesome, man. Okay, that's another person claiming that they understand now. Probably still don't. Um, this person is saying, can they pay their wife with a 1099 for all the years that we have been married, for all of these things she did as a homemaker? That's nice and it sounds good, but here's a more legitimate question. I'm not saying that their question is not legitimate, but um, this raises issues uh, and concerns um, as to um, why would he even think that he can do that? Okay, can you do this buying a house? Okay, that's a good question. Wasn't responded to. So we're going to respond to it. Okay. What do you mean by do this. Okay, and now I'm going to explain to you why I asked them that question. Because it's an open-end question. What do you mean by do this? You mean process these forms? Well, if you're not understanding that there's other things and other documentations and stuff involved, then this refers to only filling out these documents. So this person clearly does not have a full enough understanding to know what um, an acquisition is, and so instead of giving them a blatant yes or no, I answered the question with a question to help them understand that there's more to it than that. Okay. Um, this person said I must be dumber than a box of rocks because they're not understanding that, and I'm gonna respond to them to say this: you are not dumb if you don't understand what has not been properly explained to you. So he's not responsible for the fact that he still don't understand even after this alleged explanation. Still don't understand. And he's the only one realistic, not the only one, but he's being realistic in knowing that he, and understanding that it's more to it that he does not understand because it wasn't explained properly, even though some of the commenters are stating that they understand better. Perhaps they have some other previous knowledge that they've acquired that helps them to fill in the blanks that he did not explain. Hi, Chris. Thank you for sharing all of this with us. Can I pay my wife? And so this person that's asking to pay his wife uh, clearly didn't understand. Thank you so much. And this person is claiming to understand as well, I guess. First, can you do this buying a house? Thanks, brother. Thanks, Chris. I'm starting to comprehend, and I can see what kind of benefit you could share with others. Who here works for a dealership or in real estate that can take these payments, specifically in Nevada? He got some responses. Excellent question. Absolutely. It's all about finding fiduciaries who understand how to process lawful instruments like 1099As in Nevada or elsewhere. You'll need to educate or locate those familiar with trust settlements and lawful discharge methods. The paperwork must be in order. Now, he says that in the comment, but if you continue on and watch the video, he did not say that or even mention it. The chief financial officers, somebody else responded, the chief financial officers of corporations are the ones with this knowledge. You should go to them with your claim. Okay, this person understands that it is a claim. All right, so we thank them for their response. But again, the commenter is not understanding, perhaps even that it is a claim. All right. So still, we have people that's wanting to process these documents, but don't understand what in the hell is going on. Why would you? Who and why would you? Even if you're authorized to process these forms, why would you do that and so forth? Okay, this person is asking for the FIN number of the United States Treasury. He didn't get a response to that. Um, to my knowledge, people's numbers are proprietary to them. That means that's their identifying information. And just like people are processing claims of abuse of their identity in the use of using it to secure instruments and pooling agreements and so forth, some people are taking the position that their information, their ID, was stolen or used without their permission. And so, in that regard, you want to be careful that you do not use any type of information without permission as the entity, if they can fill in that information because you are unsure of what that information is, to provide that, okay? In one of his videos, Chris, one of his videos, he suggests that as well. If you don't know how to fill out each section, don't fill it out. Leave it empty for the entities to fill out certain parts of those documents. And they do have the information that is required to go in each field, and so they would can and do fill in the blanks in the system for you. Okay. Thanks for all the information. The only form I was not able to order was the 1040V. Any site on where or if it's printed? He responded to that. I called and ordered some of those documents, so I don't know why he's having a problem here. He is having a problem with that. Moving right along. You mail it to the 1500 or the 1111, or do you send it to the Austin, Texas to process 1099 if in Florida, or send them all to the Treasury? What is the time frame for payout? Thank you very much. Okay, that's a good question. Let's see what his answer was. Great question. It depends where you're filing from, 1500 or 1111 for most. But some use Austin, Texas for fiduciary filings. Always send to the correct IRS campus based on your region. Time frames vary. Study the manual closely. Now, what manual he's referring to, So I asked him a question. What manual is he referring to? Is he referring to the instructions? Okay. Says, can you use older year forms? I ordered some in 21 from Chris' original videos, or must they be from the prior year of filing only? That's a good question. You can use older year forms, but it's generally best to use forms from the tax year you're filing for to avoid processing issues. Okay. Um, I don't know if that's a correct answer. I am going to attempt the process between two EINs. See how it works out. Mm. So he's gonna try to uh, perform in a different manner, so nobody can really give him instructions on how he gonna do that realistically, without holding some liability to the answer. Uh, if it don't work out or if he get thrown in jail, no. Mm-mm. Hi there, thank you. Your delivery is fantastic. Mm, I appreciate that you up close the forms. Okay, that's nice. Where does the payment get deposited to for the trustee? Is there a space on the form for bank amount of deposit? Okay, he did answer that question. Let's see what he said. Appreciate your eye for details. If you're acting as trustee, the deposit path depends on how you frame the trust and which form you're filing. Some include space like 88888, but most require accompanying affidavits or declarations. No deposit without declaration. Now, was that an answer? Not a good one. The person didn't, must not have expected to get an answer as they would have read and seen that he responded, but it wasn't with the adequate answer, because he said if you're acting as trustee. So he made the assumption they're acting as a trustee and gave them instructions that, or clarity on details. The deposit path depends on how you frame the trust. Okay. And so, since he didn't explain what he meant by the framework of the trust has to, align with the documentation and which form you're filing. Some include spaces, but most require accompanying affidavits. And as I did already state, um, your affidavits or declaration of trust, um, deed of trust of whatever, no deposit without declaration. Okay. So there's a setup that is required. If there's a setup required to validate the benefactor, okay? As uh, the principal, why didn't you mention that aspect is extremely important to shield the presenter from liability. Asking why is he giving this type of information out so haphazardly? Then afterwards he's telling you to um, that you're supposed to have these financial instruments that will accompany the documentation for you to set up and or establish a route depository routing information, okay? Can we file these 1099s, OIDs out once the dealership give us the purchase order number? I would say yes. Yes, with your account number, you can buy. You can, but make sure the transactions qualifies in your document, and you document the security interest first. And he can say first, but I would say first. Now he telling people after the fact the old ID reflects original issue discount, so you need to prove it. There was a transaction where you were the source of the credit. Okay? So these are after the fact facts that need to be um, woven in. Okay? So you fill out all these forms together and send them in. Oh wow. Is it a bank's underwriter? What about Form 56? Where can you find the Treasury FIN number? Can you pay the taxes up front with federal tax credits? Exactly. It should be included. Can you make a video to get paid from the trust of the company via conditional acceptance? Once the forms are filled out, where it is sent to the Treasury or to the IRS. Wow. These are all questions that are very valid due to the fact that this video was not explanatory, self-explanatory, I should say. Do you have a video on how to fund a do you trust? Wow, I don't know. And I am able to use this as a donation to a church that needs a new roof. Oh, come on. Chris, I'm still trying. I've ordered Black's Law, trying to figure out how this process even starts. I don't get it. Where does the money come from? Okay. Box 6 in the 1096 says mark and X in only one box below, so I'm thinking I need to do a separate 1096 for each type of 1099. Yeah. Ah. Mm. 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 I don't even want to touch that with a 10-foot pole. Hey, Chris, again, thank you for pointing these things out and explaining the importance of reading the instructions. I appreciate you, respect you, how you show why it is so. Uh, uh, they saying the IRS no longer sends out the 1040B. I now understand how to file it. Maybe I can do something for you, Chris, in your videos. Got lost somehow when you would say, hey, this is you. And now I realize that you meant upper and lowercase u. I believe that's where most of us got confused. At least I did. Well, I think people are confused because it's a lot of things in the video was not explained. What does one do if they don't want to accept it? He liked it but didn't respond. Because he doesn't know. Okay, what to do next? What to do next if they don't respond? What do you do then? And perhaps they did not respond because you did not fill the documents out correct. So, what do you do? Learn how to send proper presentments, and they may be not responding because they're building an indictment against you for sending a fictitious instrument. They may not respond because they've already took your uh, note or instrument and securitized it, and they making money off of it, and it's in the process of maturing, and you have to wait until that instrument completely mature before you can uh, be given any distributions on the proceeds of the interest, earned interest. Okay, so I've been seeing some new videos from you, but did you put one out further explaining the very strange one you put out in regard to the authorities shutting you up on or near? It would be helpful at this point and beneficial to your credibility. Certainly. Good memory. That date wasn't random. It was calculated, and no, I haven't unpacked it yet. Some things aren't posted. They're positioned. Stay close. Mmm. Mmm. Wow. Okay. So, if that answers your question, some things is just there, positioned to it's content, y'all. It's YouTube content, and and it may be purposely presented in that manner for you to ask questions, and then that shows him that people are engaged and may want to seek further information concerning that topic or specific aspect. So I'm going to share this broadcast to our channel. So if you want to examine it, okay, okay. But on a continual basis, we are consistently reviewing law and the different aspects of agency. And so I want you all to out this video here. Hold on.
All right, good afternoon, everyone. I'm George Geis, and I want to talk with you today about something that probably few, if any of you, have heard of. It's called the law of agency. This is a session on business law, and agency law is one type of business law. Now, if you're like me, you've read some of those books on preparing for law school, right? They're always like Slaying the Law School Dragon, right? Or Inside Confidential Law School, or Exercising the Law School Demon, that sort of thing. And they do a pretty good job, I think, of giving you a basic overview of the first-year classes. They'll talk to you about criminal law and contract law and that sort of thing. But they probably don't say much, if anything, about the law of agency. The law of agency. Nevertheless, agency is a fundamental... It's a fundamental issue of law. There. In fact, agency used to be a first-year class. It actually used to be offered as a first-year class. So what is it? Why are we talking about agency law? Well, you may have heard of a movie agent, right? A Hollywood agent, or a sports agent. But the truth of the matter is that anyone can have an agent. In fact, I'll bet some of you have an agent right now, perhaps without even knowing it. You might say, so what? Why should I care? Well, once you have an agent, a number of legal implications follow, including this one. You may be legally responsible for the acts of someone else. I'll say that again. You may be legally responsible for the acts of someone else. And you might say, wait, hold on a second. I can barely be responsible for my own acts legally. And now you're telling me that I might be on the hook for something that someone else has done? And the answer is yes. Under certain circumstances, if you've got an agency relationship, you're the principal, they're your agent, you may be legally responsible for what it is that they do. So you then might say, all right, then, how do I know whether I have one of these agency things? I'd like to know who I might be legally responsible for. And the answer is that there are three major requirements. There are three things that you need to have in order to form an agency relationship. Here they are. The first thing you have to have is an agreement. The agreement will run between the principal and the agent, and it can either be an explicit agreement, something like, can I hire you as my agent and employee? Or it might be not that explicit and be something like, here's $5, will you go buy me a cup of coffee? And the agent has to then say yes, right? So you don't have to explicitly say you're an agent, just has to be some sort of an agreement. Secondly, the agent has to be acting on behalf of the principal, right? The agent has to be doing something that is furthering the principal's interest, helping out the principal. And finally, the third requirement is that the agent has to be subject to the principal's control. Now, this doesn't mean that the principal has to kind of micromanage everything that the agent is going to be doing. Rather, the principal just has to have the general right to tell the agent, please work on this, or please work on that, or please do these sorts of things for me. Once you have those three things, you automatically have this special legal relationship called an agency relationship, and a whole bunch of legal implications follow. Let me give you some examples. Who might be an agent? Well, this guy, I don't know if any of you watched that HBO show Entourage, right? Ari was a famous agent of Vince, and what that meant is that when Ari signed contracts, Vince was legally bound. Even if Vince didn't actually sign the contract, Ari could act for Vince. A second example might be a realtor, right? Some of you or your friends may have bought a home, and typically when you buy a home, you hire a realtor, and they will represent you and act in your interest and become your agent. A third example might be a famous CEO, right? Or a non-famous CEO, right? Think about Steve Ballmer at Microsoft, right? Or Larry Ellison at Oracle. They are agents for the corporation, right? Steve Ballmer is an agent and Microsoft is the principal. In fact, this is why agency law is so important for those of you that are interested in business law issues. A few years ago, Apple Computer ran an advertisement series. Here are the people. It was called PC Guy and Mac Guy. Some of you may remember this, right? And they had these two guys kind of stand up with a white background, and they'd say, I'm a Mac, I'm a PC, and they would kind of personify these two different types of computer systems. And the PC guy would be this sort of bumbling, stodgy guy who would never kind of get the answer right, and the Mac guy would be this kind of cool, hip guy, right, that would solve some sort of technology problem with a bunch of elegance. Well, if it was like this and corporations were people, then we wouldn't have to sort of ask, right, what the corporation was doing. We'd just look to see what Mac Guy and PC Guy did, right? And if Mac Guy signed a contract with Best Buy to sell a bunch of computers, you'd know that was Mac's contract. But of course, this is not how it works, right? Corporations are separate legal people, but they're not separate real people, right? At least last time I checked. And the only way the corporations can act are through their agents, right? So all the employees of a corporation should be understood as an agent. That, again, is why this issue of agency is a foundational one when you're dealing with any types of issues in corporate law. All right. Now, armed with this knowledge, right, here it is again. In order to have an agency relationship, you've got to have an agreement on behalf of the principal and subject to her control. I don't know if all of you can see that, but I'll put it back up in a minute. I want to put you in the position of judge and jury, not executioner, just judge and jury, and ask you to decide a couple of cases with me. Help me think through a couple of cases involving these agency principles. You have all the law now that you need to know. Now, I handed out one of the cases. You probably haven't had time to read it. We're not going to start with that one. I want to start with another case that you don't have in front of you, but I can give you all the facts very quickly, and then you can help me decide how would this case be resolved. What does agency law say the outcome should be? So here's the setup. The case is called Gorton versus Doty. Gorton versus Doty. There was a woman named Ms. Doty who was a high school teacher. I don't know what she taught. It was at some small town high school in, I think, Soda Springs, Idaho. And one afternoon, she's kind of walking around the school, and the football coach comes up to her, Coach Garst, and she's talking to the football coach, and she says, Coach, I understand you have a big football game coming up this Friday. Do you have enough drivers to get the team to where they need to go? Do you have enough cars to get there? And the coach said, no, actually, we're a little bit short. We need some help to get, the football players over to where they've got to be for the game. And so Miss Doty said, I'll tell you what, Coach Garst, I will loan you my car and let you use it to take the football players to the game as long as you're the one who drives it. I don't want a bunch of those rowdy 17 or 18-year-old football players driving my car. If you drive it, you can use it. And the coach said, okay, I will. Coach drove the team over in her car. They played the game. We don't know if they won or lost. But on the way back, Coach Garst, driving her car, got in an accident. He crashed her car. And one of the players who was riding in the car with Coach Garst was hurt. His name was Gorton. Gorton was the player who was injured in the accident on the way home from the football game while Coach Garst was driving. All right, that's our basic setup. Let me pause for a minute. Put on your plaintiff lawyer's hats. I know this is a business law session, right? But let's play plaintiff lawyers for a minute. Imagine that young Mr. Gordon comes in, tells you these facts. He's hurt. He's got a lot of medical bills. And he asks, who can I sue? Who? What do you tell him, right? Who can Gordon sue? Yeah.
You would both sue Ms. Doty and Coach Garst?
Okay, you might want to start with Coach Garst, right? Why?
Because he was the one driving. But then you would also try to sue Ms. Doty if there was a control agent relationship.
All right, so the first step would be to say, well, let's sue the coach, right? And I'll tell you one other additional piece of information. Let's assume that Coach Garst was driving negligently, right? Coach Garst wasn't behaving appropriately, right? He was exhilarated with the win or mad about the loss or whatever, right? And so he was swerving around. Let's stipulate that he was negligent. The automatic place you might want to go is, well, let's sue the coach. He's the one who blew it, who made the legal mistake. That's a tort. Let's go recover from him. There's a problem there. Coach Garst died in the automobile accident. Coach Garst died. Apparently, it was quite a bad accident, and I guess his estate doesn't have, enough money to recover the accident. So you said that another candidate for us to go sue is Miss Doty. I want to get to that in a minute. Is there anyone else that you might think about suing? Yeah. We might sue about the school, right? I mean, even before I go to the poor teacher, I might say, let's go try to sue the high school. That might be every 17-year-old's dream, right? But I guess, I don't think this is the law now, but I guess back at the time of the case, there was some issue of immunity. The school had some sort of immunity privilege, and so they couldn't go after the school. And so what Gordon decided to do was exactly what you suggested, is I'm going to go and sue Miss Doty. I'm going to go and sue Miss Doty. And the case is going to turn on the issue we talked about a minute ago. Is Miss Doty legally responsible for Coach Garst's negligent driving? We know he drove negligently. We have to ask, is she going to be responsible for that? And the answer is going to turn on whether we have a principal-agency relationship. Right? What do you think? I talked about the three factors, right? Let's start with the first one. Is there an agreement here? Is there enough of an agreement that we think there might be an agency relationship? What do you guys think? Yeah.
I just don't see the
You don't see the relationship.
I see the relationship if you're talking about, especially car insurance.
Yeah.
Because, if you think about car insurance, usually, you have to sign something like, these people can legally drive, I can legally drive my parents' car, they're responsible if I crash it. Or if I rent a car from somebody and I crash it, I'm responsible. So if you especially think about it in terms of insurance, she would be, liable under her insurance policy because it's her car. If somebody else crashes it, it's still her car.
Mm-hmm.
So, I mean, if you think about it that way, then she's liable in terms of, the car, not necessarily.
There may be a whole nother set of rules and issues related to insurance, right? And what does your insurance cover, and is there a presumption one way or the other, right? Totally true, right? I guess the question I'm interested in is does agency law suggest that she might be liable, even apart from what the insurance? And maybe you're saying more than that. Maybe you're saying there's policy reasons why we might want to make her responsible for insurance. What about an agreement?
Well, there is agreement that she is letting him drive the car under the condition that he doesn't let anyone else drive it. It was not for her behalf, it was for the coach's behalf.
Okay, so she said, you can drive my car, and he said, okay. So maybe we have an agreement. I don't know if it's enough of an agreement. We might have a question about whether it's enough of an agreement. But, again, you don't have to have an explicit agreement, you will be my agent. You just have to agree to be doing something. They're agreeing to be doing something, right? She's agreeing to drive his car. She's agreeing to let him drive her car. What about this subject to control? Is Coach Garst subject to her control? Yeah.
She did specifically request that he was the one to drive her car. So I don't know if that qualifies as control, but it seems like it might.
So she didn't say, only drive this fast, only take this how he could be using the car. The court looked at that and they said, yeah, there's an agreement, and this demonstrates enough control because she was able to say, you've got to drive the car, and he said, fine, I will. So apparently, right, according to the court, she had the right to control it. Now, what about this on behalf of, right? You came back to this. Was this agreement on behalf of the teacher? No, why not?
Because it's not for her purposes or her needs. It's only to help him. It's almost as if she's letting him borrow the car.
So she's doing a favor to the coach. He's not acting on her behalf. Anyone see it differently? Yeah.
Well, didn't she offer the car to him? Didn't she go to him as a teacher at the school and sort of volunteer? I mean, she's rooting for the team.
Would it change your answer if I told you that,
second.
yes, she went out initially and said, hey, struggling for cars, we can't get them?
Yeah, I mean, if she initiates the offer, then it is sort of on her behalf, just trying to help out the school. It's her purposes as well.
Okay, so what's the benefit
Right.
that she gets?
She's a fan of the school.
So she feels good about helping out the school.
Right.
Yeah.
She has her school spirit is increased.
Right.
That sort of thing. Yeah, in the back.
We'll just be limited to quantitative benefits, or would that also be a benefit?
Not always. Not always. I mean, normally that's why we would expect you to hire an agent, right? You're trying to do something, but we're not necessarily going to have to get into a valuation issue. Yeah.
So if you were supposed to drive and she said, "Hey, coach, can you drive for me? I need to save some time. I'm too busy." That might create an agency relationship.
All right.
Is a benefit.
All right.
In this instance, it's an offer.
So
I throw away my pen.
Hold on
She
one
offers.
second. Now, once he gets to explain how initially the court ruled against the plaintiff who filed a case against the teacher who offered the use of her vehicle to the coach. They ruled that the teacher was not responsible initially. But once the case was brought up on appeal, it was overturned inevitably because of the fact, just as well as the teacher enlisted her vehicle as a tool to be used for the purposes of transporting the students to and from the school event. Okay? This was not within the scope of her job duties. And anytime a public servant acts outside of the scope of their job duties, which she's required to do her normal course of business, they are liable. They are responsible, personally responsible for whatever liabilities incur during that transaction period. Okay, just as well she could have given him some type of paper saying, "This is how I want you to drive. I don't want you driving too close to people." She made the assumption that the school teacher was gonna drive responsibly. Okay, and even in the scenario he described, she told him, "I don't want any of them students driving," because of the fact that she assumed if it was a student driving that they were more likely to handle the matter in an unprofessional manner, or handle her car, be driving too fast, or whatever. Um, the point is, she made the assumption that if one of the students drove, that they may create some liability, but ignoring the fact that adults create liability, and that the teacher could have been a terrible driver. He didn't mention whether she knew of his driving abilities or whether he was a safe driver or not. In his own personal vehicle, he might drive too fast and have had 5 speeding tickets in the past or whatever. She didn't know. She didn't ask. She didn't inquire. She didn't make any due diligence to make sure that she was releasing her vehicle to somebody who would take reasonable care. Okay? And it's understood that any agent or fiduciary is expected to take reasonable care. But she didn't take reasonable care to make sure that she was releasing her vehicle to someone who also would comply to that expectation. Okay, so that's what made her responsible for her actions. She could have just as well taken the student and herself drove the vehicle, and that would have reassured her that the vehicle was being driven properly and safely under the conditions, whatever conditions they were in. Because inevitably, the only reason that the student was able to take action against her was because of the fact that she didn't take reasonable care to make sure that the person that she was relinquishing responsibility of driving herself, then the person, whoever you let drive your car, you relinquish your responsibility to them. And it should be understood that you're relinquishing responsibility to them, not to create a liability or cause an accident, however you want to work that. It's all the same. Now, if he had not been the one that caused the accident, it didn't matter whether he died or not. He caused the accident is the scenario, okay? And since he's the one that caused the accident, he was not only liable for the injuries of the students that were passengers in the vehicle he was driving, but he also is liable for the injuries to the other person and the damage to the other person or person or persons involved. Um, but the fact that he was deceased left no opportunity to seek remedy directly from him. And so, in that regard, there's no other responsible party which they could deem responsible because the school itself was not even aware that this transaction or this situation, as far as transportation is concerned, they wasn't even made aware that this was an issue that needed to be resolved by the school. Um, in that regard, I'm like, why didn't the coach petition the school to say, hey, we need transportation for these kids? That was a whole other thing, okay? And I'm assuming this is a scenario that in many of the agencies who now provide transportation to and from events do so in the school bus so that no one has responsibility to that uh, but the school, since they are the ones that um, are sponsoring the event. Um, I would even go so far as to say, um, when they said that they could not sue the school, I'm wondering, did they sue the school for that they should have reasonably known that the kids are scheduled for an event and the school should have reasonably known that these students need provisions for that, okay? To eliminate any responsibility of the teachers to try to remedy that situation on their own. And so the teachers would not have even been involved or responsible for that at all, because they would have just been, I mean, the coach would have just been acting under duty, and he would have been a passenger just like the student, um, and held no liability. Okay, and that's the way it should have been to begin with. So sometimes cases are overturned because of how the case was presented. I just want to make that clear. Um, when we're discussing what was the holding of the court, and we should do some more videos and provide some more detail and explanation of what a holding is. In other words, the court is holding their ground in their position to say this person is responsible, or they are not responsible. That is the holding of the court. If you are the plaintiff, then you need to understand what your holding is. If you're holding that the school should have been reasonably known, it was a reasonable expectation that they will need transportation to an event that was scheduled by the school or its faculty, whatever, in a normal course of business, they should have reasonably known that students would need transportation to and from the event. If they were not going to provide that to the students, then it should have been documented in such a manner, uh, clear and concise, that the students will be responsible for their own transportation to and from the event. Now, would it be reasonable to expect the students to provide their own protection? Transportation? Not at all. However, could they have relinquished that responsibility? Absolutely. They could have been like, this is a after school hours event, and so it's not covered by the transportation department, or we don't have funding to cover that aspect of it. You will have to provide your own, and that would relinquish their responsibility for that. Okay. And it had nothing to do with their curriculum. Um, that's why they call sport extracurricular activity. In other words, that's aside from what we contacting with you, what you required to do. You ain't required to be on no football team. You ain't required to participate in these type of activities. So it's gonna be your responsibility to be there if that's what you want to do. Okay? They have every right to do that. Um, you know how they say coulda, shoulda, woulda don't fly in court. You got to substantiate the claim. Who was responsible for what? And in this case, the teacher was responsible for her gift. It was a gift that came with some liability. If you offer to take me to work and I don't make it there, then you're responsible for that. And you know that saying, no good deed goes unpunished. Not to say that I agree with that. My only agreement is that in many cases you can create liability from a gift or from offering to help someone. You automatically, with the law of agency, you automatically assume the liability, that any liability that incurs during that transaction or event. Thank you all for watching. Stay tuned. We're going to have more broadcasts concerning agency, because it's very important that people understand and know what it means to affect an agent relationship as with real estate agents. Okay. You have lawyers that must comply. They have a fiduciary responsibility to their clients that's based on trust and in confidence in their competence. Okay? And so if they are incompetent, this is the reason you have the ability to file a claim for ineffective counsel. What other positions? Teachers and so forth. You have an agent relationship with them as well. When you send your kids to school, it is a reasonable expectation that um, the teachers will not uh, perform any acts that will be harmful to the children, because that's not your agreement or understanding when you sent them to school, that your kids will come back with injury. Okay. So in relation to forms and documents and so forth, when you send your documents to the IRS, you're not expecting for them to send you back a frivolous filing. You're expecting them to process your documents to your benefit. And so that's why it's important to establish their fiduciary responsibility when you process the documents. Sometimes people will relinquish them I say them, whoever you're sending the documents to, you may relinquish them of their responsibility to the document by sending in a Form 56. 56 is fiduciary duty. If you say you being responsible, then you responsible. So I even noticed that in the comment section, people were asking, do I send a Form 56? Well, Form 56 is to notify the IRS of who's responsible, who's the fiduciary. And so you saying I'm the fiduciary, I'm responsible, I know what's going on. Well, that's counterintuitive, because you don't know what's going on if you were on this broadcast asking. Okay? I mean, on his video content, they're asking the questions. Do I send a Form 56? They're not asking who should I make the fiduciary, or who should I assign the fiduciary duty to. They're asking, do they need to submit a Form 56, okay? And so that creates a liability for the person who is listed on that form. Okay? So let's be understood. Hey, we got another subscriber. Come on in and put your 2 cents in. Thank you all for joining me. I appreciate the new subscribers. We got 2 subscribers just during this broadcast. So we're grateful for that. Stay tuned, and we're going to have more broadcasts to help you understand documents in general. We're going to help you understand documents specific. When you see that we're broadcasting and we have made that broadcast in a style and in a manner where you can ask questions and receive uh, intelligible answers. Okay? Participate. We encourage you to participate. Stop going in these comment sections asking vital questions like that. That's unintelligible. Okay? To go on a video uh, comment section and ask such a detrimental question. In other words, if you don't get the answer to that, any actions you may take without having sufficient knowledge is detrimental to you, then why would you take actions? And here it is the presenter or anyone for that matter that may see your question. No one has responded. Why would you take action? And people say, I sent this off. Was that okay? Well, why did you send it off if you didn't know it was okay to send it off? That part. Thank you all for joining me. Stay tuned.